My Lord, I think the state has answered my question, my Lord, to say the service provider, I expect, is still busy with the...
Yeah, fine, but the
Yes.
statement is supposed to have been sent to you on your WhatsApp address.
The Mohale statement, my Lord, was discovered to me last week on Wednesday.
Yeah, okay.
The statement, which is marked Exhibit XCC, my Lord, was just discovered during break today. My main problem, my Lord, is the Section 205.
But it says the service provider at Vodacom is busy attenuating that affidavit
Yes,
to restrict it from 4,000 pages
yes, ma'am.
to the cell phone numbers which are relevant in this case.
Yes.
That's how I understand it.
And then, my
And it
Lord...
says it will be furnished to you guys.
And then, my Lord, what I've suggested to the state is that we then pause with dealing with the evidence relating to the cell phone and then continue with other evidence until we receive that cell phone evidence, my Lord, so that I will be able to consult properly. Because if my Lord, this evidence were of Mohane was going to be allowed, it means now I will have to consult in piecemeal evidence, and also I won't be in a position to construct a proper defense regarding the evidence of the cell phone that the state is intending to lead. Hence, I'm asking, my Lord, that this evidence of the cell phone evidence relating to Mohane and all other witnesses be paused at this stage up until such time when I am finished with the Section 205 records, so that I will be able to take proper instructions from my client.
Yeah, okay.
Yes.
Yeah, Mr. Baloyi, what are you saying? Nisi, before you.
Thank you.
What are you saying, Mr. Nisi?
I understood, my Lord, that I was still on the podium, but be that as it may, was posing a very point of concern that the state indicated that disclosure of Mr. Mohane's statement was made at the time at which the entire content of the case docket was disclosed. I'm also not trying to cast any aspersions, my Lord, but I think it suffices to mention that according to the document that you were handed with today, last week, Mr. Mohane's statement was only proposed on the 5th of September 2023 at 14:45. That's the first statement. The second statement that I have that was handed to me last week as well, the statement was also deposed to on the 5th of September 2023. So that basically is indicative of the fact that it is not entirely correct, my Lord, to suggest that disclosure of the statement of Mr. Mohane was done at the time when the entire content of the case docket was disclosed to us, my Lord. This then brings me to the following point, my Lord. It is apparent, my Lord, it is beyond reproach that at the time at which the state decided to indict this person and marched them to court and for their first appearance at court, the state was not yet ready to embark on that process, man. This is evinced by the fact that each time there's a particular investigation that is actually going on. That is what the state has already considered too. Cell phone records are not yet ready even at this point. From 2014 to 2023, cell phone record. Let me actually limit it to the time at which this accused person might have been arrested, which is 2020. It's almost 3 years now, but cell phone records are not yet ready, my Lord. Now, the problem that we have with this kind of an approach is that each time we put a version to the witnesses that the states are calling, they come up with something new. Then come the next witness, we are also expected to put a different version from the first version that we would have put to the witness, on the basis of which we couched our defense based on the information that would have been available then, my Lord. This prejudices the accused person's defense in their case, my Lord, because at the end of it all, we are going to argue about the credibility and the honesty and the reliability of what these witnesses are saying, my Lord. It seems to me like the state was not ready from the beginning. And if that is the case, my lord, it is not an embarrassment for the state to stand up and say, my lord, we are still busy investigating this case. We're therefore requesting a very long postponement of this case. I don't think any colleague of us was going to object on that one, my lord, because then we would know that come that point, after that very long postponement, then we know that the state would have said, you know what, we've got all the information now. This is going to be a machine and a train that is going to run from Pretoria to Durban without any stops and goes, my lord. But as things are now, I can tell this court, my lord, from the solitude of my conscience, that we are yet expecting another surprise in terms of new evidence that is going to come up from somewhere, and that is going to necessitate this stop and go issue, my lord, which I say in the main is prejudicing the manner in which we are couching the defense on behalf of our clients, my lord. I would therefore request, my lord, that the state should come up very openly and indicate whether are we yet supposed to, are we expecting yet another surprise in terms of new information that is going to come up from the investigation that is ongoing in this case, my lord. But then if that is the case, I would have no objection that the state come up openly with the court and say we're requesting for a very postponement, a very long postponement, so that we complete investigation in this case and then we take it from there, my lord. But as things are now, I'm afraid, my lord, the fair trial that these accused persons are supposed to be enjoying in terms of their constitution, my lord, is not seen to be happening in this trial. Thank you, my lord. And these are not casting of any aspersions,
Yes,
my lord.
Mr.
It's just an observation. Thank you, my lord.
My lord, I share the very same sentiments with my colleague in that the accused are not afforded the right to adequately prepare for their defense, which the conduct of the state is inconsistent with the provisions of Section 35, subsection 3B of the Constitution. In as far, my lord, as the Section 205, I had concerns about the Section 205 records, but the state has indicated that they will be furnished to us later. Thank you.
Okay. Yes, Mr. Baloyi.
As a court, please, my lord, perhaps two issues. I think that was very clear that one is making an assumption that in light of the fact that the statement is marked that it would have been supplied, but the fact of the matter is that it was supplied last week Monday, and I don't understand what the problem is now. Is it the late disclosure of the statement, or what the problem is at this stage, my lord? We've always been very candid and open with the defense. If they want more time to engage with any of the evidence that the state will be leading, we don't have a problem with that, my lord. But we went through the evidence of stain. There was reference to Section 205. There was no problem at that stage regarding the Section 205s. We disclosed the statement of Lieutenant Colonel House regarding the analysis of the phones of accused 2 and 5. They requested more time, which was given to them at that stage to prepare. Now, today it would appear that they are raising another issue of Section 205s. My lord, in any trial, there's massive information at the beginning of the trial. Some of it might appear not to be relevant at that stage, but later on during the trial, it becomes relevant. And focus, the defense, we must keep in mind that we didn't even know what the defense is going to be of the accused. And when a version is put to the witnesses, then it becomes clear what the version of the accused is, and that massive information that was accumulated at the beginning of the trial will then be looked at, my lord, and the relevant portions as is indicative from the version that is being put to the witnesses will then be analyzed. And that is situation in this matter. If the defense was to say, listen, we need more time to look at, these issues, we don't have a problem with it, my lord.
So this, what's the name of the section 205 witness?
It's from
From
Vodacom.
Vodacom, yeah.
Yeah. It's Miss Pinky.
It's Pinky?
Pinky, I'm just trying to
Okay.
look at her surname. It's a very difficult one. But her first name is Pinky.
Is that the Indian lady?
Yes.
Yeah, I seem to recall her. She's appeared several times in my courts.
I'll give
So just
the
tell me,
same
when
name.
is she saying she'll be ready with the...
Well, when I communicated with her sometimes last week, she said from the 6th of
October?
October.
True?
But yeah, we're still waiting for the affidavit.
Yeah, okay, fine. Do you have any other witnesses besides...
Well, I indicated to my learned friends that we can call this witness who merely testifies about the confiscation of the cell phones. Yeah, the surname is, I'll spell it, is VY.
Yeah.
THILINJAM. Sorry, GAM
Yeah.
is Fidiligam.
Yeah, fine.
I indicated to my learned friend that we can call the DNA expert who's available.
Is he around here?
He said he can be here at 2 o'clock. We can then proceed with, if we're not going to leave the evidence of Mokhani, we can proceed with the DNA
Yeah.
analyst at 2.
Let's reassemble at 2. Unless, of course, you haven't supplied the DNA results to all the councils here. Have you been supplied with the DNA tests and results?
DNA results, we have them, my lord. They're just neutral. They don't say
Have you
anything.
been supplied with the DNA results?
Yes, I confirm.
Mr.
Thank you.
Trevor?
Yes, I confirm, my lord.
Okay, 2 o'clock. Then we'll listen to the evidence of the DNA.